Hello everyone, welcome to Steno Aspirants. Get ready for legal dictation containing 720 words at the speed of 90 words per minute. 3, 2, 1, start. The challenge by the appellant is threefold. Firstly, it is contended that prior to the respondent bank acquiring the said property in an auction sale, the same had been re-entered by the Land and Development Office of the Government of India, being the lessor of the land underneath the property, and thus no title was acquired by the respondent bank, and the said property was not public premises within the meaning of section 2 bracket E of the PP Act for the estate officer of the respondent bank to pass an order with respect thereto. Secondly, it is contended that no bona fide requirement on which ground the appellant was sought to be evicted had been established, and rather it stood admitted that the eviction of the appellant was with profit motive. Lastly, it is contended that no proper opportunity to lead evidence was given to the appellant by the estate officer of the respondent bank. As far as the first of the challenge aforesaid is concerned, the admitted position is that when the respondent bank, after bidding for the said property in an auction, had applied to the court for confirmation of the sale in its favor, the Land and Development Office had objected on the ground that the property having already been re-entered, no title could be conveyed to the respondent bank. The said application of the Land and Development Office was rejected, giving liberty to the Land and Development Office to seek its remedies. Not only so, the Supreme Court in Shanti Sharma versus Ved Prabha 193 has held that re-entry effected by the Land and Development Office of lease with respect to the land underneath the property does not prevent the lessee of the said land from seeking eviction of his oblique her oblique its tenant in the property constructed on the said land as owner thereof. It was held that unless the Land and Development Office, pursuant to the said re-entry, reposes the property, the lessee of the land is fully entitled to deal with the tenants inducted in the property constructed over the said land as owner, landlord, and the tenants of the lessee cannot challenge the title of their landlord. Upon the senior counsel for the appellant being confronted with the said judgment, he had no reply thereto now. Therefore, it has to go by the earlier decision of the court, which has decided that matter justifiably as such. He contends that the Supreme Court in the said case, in a case of re-entry by the Land and Development Office, had directed the possession of the premises to be delivered by the tenant to the Land and Development Office and not to its landlord. We have on Deemer asked the senior counsel for the appellant whether the appellant is willing to hand over possession to the Land and Development Office. If not to the respondent bank, the answer is in the negative. The said conduct of the appellant demonstrates the malafide of the appellant in seeking to retain possession of a valuable property in the prime central business district of the capital city of Delhi on some pretext or the other. The judgment in Bharat Sales Limited Supra turns on its own facts. That was a case under Section 14 of the Delhi Rent Control Act 1958 and in which proceedings the Land and Development Office was also a party. Such is not the case here. On the contrary, the plea of the Land and Development Office has already been negatived while confirming the sale in favor of the respondent bank. The Land and Development Office, having not taken any steps till now for repossessing the property, the appellant cannot wriggle out of eviction order if otherwise found to be validly passed by setting up a title in the Land and Development Office. Moreover, the respondent is a nationalized bank and the Land and Development Office has a policy of revoking the re-entry upon the reasons on account whereof re-entry was effected being remedied and the charges therefore being paid. There is nothing to suggest that the said charges cannot be recovered from the respondent bank. We therefore do not find any merit in the said ground of challenge. As far as the second ground aforesaid of challenge is concerned, the finding of the premises being required by the respondent bank is a finding of fact. Stop. Yes, get ready for general matters containing 720 words at the same speed. 3, 2, 1, start. Sir, the Honorable Finance Minister has told us why he has thought fit to bring these finance bills in the middle of the year. The plan contemplated a tax of about rupees 400 crores, and now that the finance minister does not want to take recourse to deficit financing, naturally the tax has got to be increased and it now comes to about rupees 1300 crores. Therefore, money must come from wherever it can be had, and some sort of tax has to be imposed. Now, the proposals have to be examined from that point of view. Some people have acclaimed the proposals as very necessary and well considered, while others have found ground for criticizing them. Whatever may be the taxation measures, if they are applied properly and with sympathy, even measures which are not liked can be made to be appreciated and less objected to. I have no doubt, as the finance minister himself said, that he will see that the measures are sympathetically administered, and if that is done, most of the objections that might be and have been put forward to the proposals would be removed. As you may remember, when the 5 year plan was discussed in this house and in the other house, some of the members felt that perhaps a very optimistic view might have been taken of the resources that may be available for carrying out the 5 year plan. Even now, people feel that the plan has got to be implemented, and a lot depends on the implementation of the plan. But the question, have we taken note correctly of the resources that are available, and have we not overestimated and taken rather an optimistic view? But implementation of the plan will not be very much affected if instead of 5 years a few months are taken to implement it. What I mean to say is, if the resources are not sufficient to carry out the plan in 5 years, there is no harm in increasing the period by a few months so that there may not be a very heavy strain on our resources, and so that things may not go wrong on account of the heavy strain that may be put thereon. Another thing that can be looked into very conveniently is whether or not a certain amount of savings can be effected. So far as the proposals in the two bills are concerned, I have one or two suggestions to make. One is regards the capital gains tax. Most of the exemptions that were in the previous act have been removed, but I feel that so far as capital gains in respect of compulsory acquisition by government is concerned, that should still continue to be exempted. When a person sells his capital asset and makes a gain, which is called unearned profit, he may be taxed, and perhaps he will have no justification in raising any objection. But when a property is acquired which he does not want to sell, but which is acquired under compulsion at the instance of the government for the use of the government, in the case of such a compulsory acquisition, there is no real justification for making the man pay capital gains tax also, especially when he never wanted to part with his property, and in fact he objected thereto but had to part with it because the authorities wanted him to do that. That is one small suggestion so far as capital gains tax is concerned, and I think in a case where compulsory acquisition takes place, it is for the government to consider whether or not they will think of giving relief to the unfortunate person who may have to part with his property in spite of himself. Another suggestion that I have to make is that so far as compulsory deposit is concerned, the people who are conservative and who have put in careful and prudent management and have built up resources generally use them for the purpose of increasing the volume of business and stabilizing the position of the company. But here the position is just as if you are going to penalize those companies which have prudently managed, which have been managed in a conservative manner, and which have not frittered away their resources. Stop over.